This courtroom hearing starts with a woman already on thin ice, and within minutes, the judge is warning her that one wrong move could send her to prison for up to 20 years. The defendant, Glenda Willa-Lifford, isn't here for a brand new crime. She's here because prosecutors say she violated the terms of her probation after previously receiving deferred probation for aggravated assault with a deadly weapon, a serious second-degree felony. And let's be honest, when a judge starts talking about revoking probation, things can go south very fast. Now, here's what makes this hearing so intense. The court actually seems willing to help her. Prosecutors, probation officers, and the judge are discussing treatment programs instead of prison time. But the question is whether Glenda can hold herself together long enough to receive that second chance. Because in these courtroom situations, attitude matters just as much as the paperwork. One emotional outburst, one disrespectful comment, or one bad decision can completely change the direction of the hearing. As this case unfolds, you'll hear allegations involving failed drug tests, incomplete anger management classes, and unpaid court fees. But beneath all of that is a bigger issue: whether the defendant is genuinely struggling or simply refusing to follow the rules. And trust me, the judge is paying attention to every word, every reaction, and every excuse. What starts as a routine probation hearing quickly turns into a tense emotional moment that almost blows up the entire plea agreement. Watch closely, because one sentence near the end completely changes the mood in this courtroom.
And there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Mr. Rojas, you have Glenda Willa-Lifford. Good morning.
Thought I saw somebody spill some coffee earlier.
It wasn't me, somebody spilled it on my stuff.
Good morning, ma'am. Are you Glenda Willa-Lifford? And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to go into special needs safety.
Thank you. All right, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Willa-Lifford, in cause number 24 DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that
We've agreed to go on counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
At this point in the hearing, the legal stakes become crystal clear. By pleading true to these probation violations, Glenda is essentially admitting that the violations happened. And that's a massive deal in court. Once a defendant admits to violating probation, The judge suddenly has enormous discretion. She could continue probation, extend probation, order treatment programs, or revoke everything and impose prison time immediately. What's interesting here is that the court isn't treating this like a hopeless situation. The recommendation for a special needs safety program tells us the court likely sees underlying mental health or substance abuse issues contributing to the behavior. That's why the judge keeps emphasizing understanding the agreement and waiving appeal rights. But here's the thing viewers should notice. The judge is being patient, yet very cautious. She keeps slowing things down, asking if Glenda understands, making her speak up clearly and confirming every step on the record. So, let me ask you, if someone repeatedly violates probation but claims they're struggling personally, should courts focus more on punishment or rehabilitation? Because this judge seems to be balancing both in real time.
Speak up, please. And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today, and is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of
This
state.
right here is the turning point of the entire hearing. Listen carefully to the way the judge phrases this warning. There will not be a third chance. That's courtroom language for, you are standing at the absolute edge of prison time. And honestly, the defendant just caught a huge break. The judge already stated there was enough evidence to revoke probation and find her guilty. Legally, prison was absolutely on the table. Instead, the court is choosing treatment over incarceration. The judge specifically mentions drug abuse counseling, mental health assistance, and structured supervision. That tells you the court believes the defendant still has a possibility of rehabilitation. But there's also frustration underneath the judge's tone. You can hear it. This isn't unlimited sympathy. This is conditional mercy. And notice something else. The judge isn't just speaking legally anymore. She's speaking personally. She wants the defendant to understand the seriousness emotionally, not just procedurally. That's why she keeps repeating phrases like, listen carefully, and you need to take advantage of every opportunity. Judges often see the same defendants come back over and over again. So when one of them pauses to give this kind of speech, it usually means they're making one last effort before harsher punishment becomes unavoidable. The big question now is whether the defendant realizes how close she came to losing her freedom today.
When you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had the statement prepared for you, explaining the only reason I was doing marijuana at the time is because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden It's all that I'll never touch the shit again if you let me go home.
Are you seriously going to stand here and talk
No.
like that?
And there it is, the moment that almost completely derails the plea agreement. The second Glenda uses inappropriate language in court while begging to go home, you can feel the entire atmosphere shift. The judge immediately stops her and calls out the disrespect. And some viewers might think the judge overreacted, but courtroom decorum matters more than people realize. Judges pay extremely close attention to how defendants conduct themselves during emotional moments. What makes this scene so dramatic is that Glenda appears genuinely terrified. She starts talking about cancer pain, marijuana use, and fear of prison all at once. And emotionally, she seems overwhelmed. But from the judge's perspective, there's a major difference between being emotional and being disrespectful inside a courtroom, especially when you're already receiving leniency on a serious felony probation case. And here's the scary part. The judge openly reminds her that she does not have to accept this plea agreement. That means the deal was still hanging by a thread. One more outburst or one more bad response could have changed everything instantly. Imagine being seconds away from avoiding prison and then accidentally talking yourself into a harsher sentence. That's exactly how dangerous these courtroom moments can become. So what do you think? Was the judge being too strict about the language? Or was this a fair reminder that respect matters when your freedom is on the line?
Talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Okay.
In the end, Glenda Williford walks out of this hearing with something many defendants never receive: another chance. Despite multiple probation violations involving failed drug tests, failure to complete required programs, and unpaid fees, the judge decided not to revoke probation today. Instead, the court extended her probation by 1 year and ordered her into a special needs safety program focused on treatment and rehabilitation. But make no mistake, this was not a victory lap. The judge made it painfully clear that prison remains a very real possibility if the defendant violates probation again. And honestly, that final emotional exchange may have shown exactly why the court is conflicted. On one hand, the defendant appears overwhelmed and struggling personally. On the other hand, the court expects accountability, discipline, and respect, especially in a case involving aggravated assault with a deadly weapon. This hearing perfectly shows how probation cases often become a balancing act between compassion and consequences. The court tried to offer support, but also drew a hard line about personal responsibility. And now, the future is entirely in the defendant's hands. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe to Judge Verdict TV for more jaw-dropping courtroom breakdowns and real legal drama.